Yes, Mr. Zen, just before you start, I've got a question for you. If I can try and encapsulate it. This morning, I asked you, mistakenly I think, whether we were dealing on ground 1 with an appeal from the Upper Tribunal, and you agreed. But in fact, we're dealing with an appeal from the decision of the First Tier Tribunal that was dismissed on ground 1 by the Upper Tribunal. So the relevant grounds of the decision are to be found in the First Tier Tribunal for our purposes. Am I right about that? Second question is, if we are dealing with the FTT decision on family life, and if we were to hold that the test for family life, as you submitted it was further elements of dependency involving more than the normal emotional ties, rather than the test in Lord Justice Sedley's judgment of effective, real or committed support, right? With me so far? Yes. Then, as the note we received over lunch from the Secretary of State confirms, again, I think correctly, that the FTT can only have applied the support test, because it says at paragraph 25, since the start of the conflict, the sponsor has clearly provided genuine, effective and committed support to the appellants. So if that is right, and if therefore, let's assume on this analysis that the wrong test has been applied by the FTT, do you accept or not that we have to allow the appeal and remake the decision on ground 1 applying the facts to the correct test? Applying the correct test to the facts. But think about it. You don't have to.
Can I just think about it? I think it's quite lovely.
Yes. I'm going to ask Sir James the same question in reply. Normally judges say, I don't want to take you out of your course, which is never true, but in this particular case, I would like you to continue with your submissions on ground 2.
Yes, yes.
Whilst your team of juniors is thinking about the answer to that googly.
They're the Sachin Tendulkar facing Shane Warne to my...
Sorry, back to where?
I'm making a
very inapposite...
Oh, Tendulkar. Yes,
cricketing
back to cricket, yeah.
So you're Shane Warne. I'm not even close. Ground 2. I'll come back to you. Ground 2.
Yeah.
We'd established that ground 2 is not relevant to ground 1 because you look at family life from both sides, both perspectives.
And I would like, I think you said Sir James agreed with you, but I'd like him to confirm that when he replies.
Of course. Sir James also accepts that you look at all the circumstances, but then you exclude anything from the perspective of the people abroad when you're seeking to justify under Article 8.2. Now, we agree with you, my lord, the Master Rolls, that is jolly difficult and very odd. So you look at the issue from both sides to determine whether there is the family life. We know that it's the family life that requires protection. You can look at all the circumstances relevant to the family life and all the circumstances that are relevant to the impact that the decision has on the family life, but yet you're supposed to then leave out of account the perspective of the people who are abroad, despite the fact that you're protecting that family life and looking at everything. Very fine distinction. And the simpler thing, in terms of you're going to give guidance, what are the tribunals supposed to do about this?
It always comes down really to what they mean by talking about family life being unitary.
Yes, it's a single concept. It's a relational concept.
I think what Sir James would say is that even if family life is unitary, whatever that really means, you are considering the Article 8 rights of the sponsor.
Yes.
And therefore you are looking through the telescope of the sponsor, not through the telescope of the family rights, i.e. the Article 8 rights of the family in Gaza. It
falls on me to say that analysis is wrong in law, 2A, and even if it's not 2B, if you like, doesn't make any difference. So, point of detail, the point wasn't argued before the tribunal below. You can see that from its decision on permission to appeal, pages 198 to 199, paragraphs 27 and 30. Obviously, it's an important point, and your lordships and ladyship will rule, but I'm just giving you that for context. But the point of this, Sir James explained, was that it is about focus. And the idea is, if the people abroad are rights holders, then you assess circumstances in Gaza rather than the impact that a denial of entry clearance would have on the sponsor's enjoyment of family life with them. And that's the Secretary of State's skeleton at 34. Now, in contrast with respect to Sir James, I want to take you straight away to the tribunal, because we say it's very clear that the tribunal's consideration was free from legal error because it looked at those circumstances precisely in the context of what impact would the denial of entry clearance have, not how bad is it. Although the latter question obviously is relevant to the impact, but it absolutely did look at the impact. Can I ask you to take up, I think you haven't been asked to go to the tribunal very much, or I suppose Sir James counted through it, but certainly all submissions didn't tell us what was wrong with this. We go to page 126 of the core bundle.
Could you use paragraph numbers?
Of course. 164. So, current circumstances in Gaza as a factor in favour. Mr. Kiriko submitted that was of itself sufficient. They say no. We'll attach significant weight to it. And 166 is illuminating. We make it clear this is an Article 8 family life case. We're not treating it as some form of disguised protection claim. So James says that the UK is not responsible for the circumstances in Gaza. And of course, that is right. We've never suggested that it was. But it absolutely is responsible for respecting the Article 8 rights, we say, of the family, at least of the sponsor. Takes Sir James nowhere, the idea that we're not responsible for Article 2. The conventional, if we could carry on from the tribunal, if the conventional proportionality exercise requires us to take account of all relevant considerations, the appellant's current circumstances, one such consideration, because it goes to, and here this is the nub, the core issue of whether the family life, that's not just the unit there. It's the sponsor and respondents' family life. Respondents, apostrophe after the S, family life can continue, because that's the family life they found. That's what gives you the jurisdictional link. Whether that life can develop in the future, remember Lord Justice Dyson in the first Singh case, paragraph 38, where he talked about the potential for development is relevant, and the risk that it will be extinguished by virtue of their death. And I'll come back to resettlement scheme. This is not a case concerning Articles 2 or 3. And the appellants do, in fact, enjoy a protected right. And then they cite Al Hassan. And then, my lords, my lady, 171, focusing on the family life as it stands, we agree with Mr. Kiriko. The two elements to acknowledge, actual family life and the potential. In respect of the former, it stands to reason that were the risk of death faced by the appellants on a daily basis to materialise, the family life currently enjoyed would be extinguished. That element goes to the seriousness of the interference with the family life rather than to its strength when considering proportionality. The second element does bear directly on proportionality. We found the sponsor doesn't regard cohabitation in the UK as simply a short-term solution. He's fully committed to supporting the appellants for as long as it takes. There were pictures of accommodation he'd looked at out of London, Reading, I think was one of the places. Based on this, we're satisfied that the extant family life would develop. It's highly likely to strengthen over the course of time, etc. So they're absolutely looking at conditions and circumstances in Gaza as they are relevant to family life, not by way of some extra jurisdictional freestanding protection claim. And equally, the concern, Sir James's concern, is that, look, this drives best interests. You get best interests and the sky will fall in. We respectfully submit their approach to best interests was absolutely free from error. If you look at their best interest consideration, it's at page 122.
Paragraph.
Sorry?
Paragraph.
I'm sorry, my lord, I'm so sorry. 141 through to 146. And it's bookended by an impeccable self-direction. Best interests are a primary consideration, and at 146, not the paramount consideration. That's absolutely correct. And then 142, fifth and sixth appellants now 7 and 9. Young children, in our judgment, it's reasonable to infer they've been less able to withstand what's been happening since October 23 than with children approaching adulthood. Not that the occurrence established some form of emotional or psychological bright line. You remember there are cases to that effect. The two children are at high risk of death or serious injury on a daily basis, living in conditions of extreme, in view, unjustifiably harsh, difficult to conceive of a situation more contrary to their best interests. Self-evidently and overwhelmingly in the best interest of the two children to be in a safe environment together with their parents and siblings. So there's nothing legally wrong with that, because as Sir James, I think, accepted, whilst Section 55, the statute which domesticates best interests, Article 3 of the Child Rights Convention, while that's limited to in the UK, Strasbourg regards best interests anywhere as relevant. I think Sir James accepted that. If he didn't, I have authorities that you refer to in the skeleton and I can point you to.
Sorry, you're going to have to speak up a tiny bit.
Sorry, my lord.
I'm losing you. You're dropping off.
I'm so sorry.
Strasbourg regards the best interest of the children as relevant to everything?
Yes, wherever they are. When you've got an Article 8 family life case, Strasbourg does not exclude the children who are abroad does not exclude their best interests. Now, I think Sir James accepts that, because he says you've got to look at the circumstances everywhere, and all he said was, a bit of a straw man, he said, lest it be suggested that this would be inconsistent with Article 3.1 of the UNCRC. Well, where exactly is that contention? Where is that self-direction in the Upper Tribunal's decision? It doesn't exist. But it's in that context that he says, look, there's this territorial limitation. But there's absolutely no legal error there at all. So quite what the concern is here, we submit in ground 2, we're not clear. But I wanted to take you to the Tribunal's decision early, so you actually looked at it in the context of this ground. Can I then make submissions of law about who is the rights holder? Now, I want to look at domestic authority, or make certain points concerning domestic authority first. I just want to make 3 points. AS Somalia, we respectfully submit that Lord Hope's reasoning in AS Somalia. AS Somalia is at tab 10, page 171. I should, before I say this, I should immediately accept that there are many cases, I agree with Sir James, there are many cases where jurisdiction is taken as read, or it's not considered, or the argument isn't made. I accept that. However, that's not the position in every case, at all. In AS Somalia, we respectfully submit that the principle in Bioku Betts, so I'm looking please at page 177, tab 10. At paragraph 16, Lord Hope, we say he effectively extraterritorializes, probably not a verb, he applies the Bioku Betts principle in the extraterritorial context. Lord Hoffman agrees with him, paragraph 11, and so does Lord Brown at the end of the report. I agree that everybody agrees with Lord Phillips, but there are effectively 2 majorities, we say. The primary submission is that this is binding. Secondary submission is it's highly persuasive. And what we say is that in paragraph 16, the unitary nature of family life, your Lordship asked what that meant. What it means is in the middle, we say, of paragraph 16, letter C, Baroness Hale in Bioku Betts, the right to respect for family life of one necessarily encompasses the right to respect for the family life of others with whom that family life is enjoyed. Before that, he says it's not difficult to see that there may be entry clearance cases. Indeed, there may be many which engage the applicant's right to respect for his or her family life. Entry clearance, ex hypothesi, you've got somebody outside. There may be cases which don't engage respect because the family life is exiguous, but there may be many cases that do. When they do, Baroness Hale applies. Bioku Betts. The questions that these cases raise is whether any interference with that right, which results from the rule that the section lays down, is incompatible with Article 8. Article 8.2 declares there should be no interference except in accordance with the law. The points that my Lord made in the present context is to the phrase in accordance with the law. So that's essential to his reasoning. and we say it's binding, or at the very least, highly persuasive. The second case I wanted to refer to is the Abbas case. All I want to say about that is that we accept its obiter, but the statements of law contained within it, which you've already seen, are correct in law. And that's Lord Justice Burnett, jurisdictional heart in the right place, Lord Justice Ryder, and Lady Justice Gloucester. Abbas is AB tab 22, Authorities One Law, tab 22, page 474. Except it's obiter, it's a private life case and not a family life case. The case I do want to take you to, if I may, is the case of Ali, which your Lordship said he remembered. It's a very unusual case, but it's very helpful because we see, because it's domestic authority for the proposition that you can be an Article 8 rights holder and not be in the UK through a jurisdictional link, quote unquote. And indeed, there is Strasbourg case law which says that. So please can I, it cites a Strasbourg case which is analogous to the situation in that case. Ali is at tab 31. So this is Lady Justice Andrews, and she says, paragraph 1, it's the most extraordinary case. We accept that.
The page number.
633.
Thank you.
She considers the decision in Abbas at paragraph 31 onwards, and then the key discussion, these key paragraphs are at 40 to 43. Sorry, 39 to 43. So she concludes her review of Abbas, say, this distinction carried through to an obiter discussion whether the applicant and Abbas and his wife and children fell within the jurisdiction of the UK for the purposes of Article 1. The Justice Burnett accepted the argument they didn't. The Supporter emphasised they were nationals of other states who had not established private or family life in the UK. And then at the top of the page, page 642, that passage says nothing about the position of someone with an established family or private life within the UK. And then there's a discussion, she limits Abbas, and then says, at 43, the appellant wasn't seeking to develop a private life in the sense using Abbas, but rather to resume or continue a long-established private life within the UK, which had been curtailed for reasons beyond his control. He was a settled migrant with indefinite leave to remain. It was that pre-existing family life within the jurisdiction that provided the jurisdictional pay. Sorry?
Private life.
Or did I say family? Sorry. Pre-existing private life within the UK jurisdiction that provided the jurisdictional pay for the purposes of Article 1. So, very clear signal that where the language of jurisdictional peg is used, certainly in domestic case law, it's not saying, well, there's someone here and you can look at the whatever's protected family life just from the perspective of the person who's in the contracting state, who's in the UK. Because there's nobody in the UK here. And it doesn't make sense to say that Article 8 analysis here is from the perspective of the abstract private life enjoyed in the UK. It's from the perspective of the individual who is outside the UK. I go back to the point I made before. If you've got someone in the UK, there's no need to talk about jurisdictional links or jurisdictional pegs because they're in the jurisdiction. And then at 48, she looks at a Strasbourg case, an Azerbaijani case called Sasgian, and notes that the facts were complex. At 49, Strasbourg found Article 8 was engaged. He had a home in Gulistan, which he had left involuntarily in Azerbaijan. He was an ethnic Armenian. 50, his lengthy involuntary absence from Azerbaijan didn't preclude him from arguing successfully the refusal to allow him to go back into Azerbaijan was a disproportionate interference with the private life he'd established in that state. And then 52, in Saskian, the applicant was physically outside the state and complaining about the denial of re-entry, been away for many years, settled and developed a private life in another state. And that decision contradicts the broader interpretation of Abbas intended for by the Secretary of State. There may be scenarios in which the private life of an individual developed within the host state who's no longer within that state will be sufficiently engaged for archaic purposes by refusal of the right of entry to that state. Again, very important and interesting authority supportive of our reading of the case law.
My lords, if my learned friend is leaving that case, could I just invite you to read paragraph 39?
Sorry, I've lost it. I put it away. I think Sir James wants me to read the last sentence on 39. The rights of their elderly relatives who are within the UK may have been affected for the purposes of an argument based on Article 8 family life, but there was no jurisdictional connection for private life purposes. Do you remember that Abbas is a private life case? It's got nothing to do with family life, so that's neither here nor there. Sir James's whole point is that the observations about family life in Abbas are overturned.
But Ali's a private life case too. I'm not at the moment seeing how it helps you because it all turns on private life developed by the appellant while he was in the UK.
Yes, and it's that, the reason it helps me is because what's said against me is that when we look at this idea of jurisdictional link, that is simply a mechanism of bringing the family life in abstract, as it were, or just the concept of the family life that's enjoyed into the jurisdiction. But the rights holder is only the person here. That's what's said against me. That analysis cannot survive this case. Why can't it survive this case? There's nobody here. The jurisdictional peg or link is supplied by the previously established family life. Once that is established, there's no jurisdictional problem. There's no extraterritoriality, even though the individual is outside.
But that's because the individual had rights under the convention.
Yes.
Established by the jurisdictional peg of living in the UK.
Yes.
And didn't lose them automatically just because he went on holiday and lost his passport.
Yes, and in our case, the respondents have family life rights on the finding of the tribunals below, and it's their rights. It's not just the sponsors, they're rights holders. This man is a rights holder, even though he's outside at the relevant time. The issue, it's an immigration decision he's challenging. It keeps him out of the country. Right, sorry if I haven't put that as clear as I could have done. The argument that Sir James advances is you've got two people, one's outside, one's inside. They've got a family life. So he says there's a jurisdictional link, and what that does is it brings the issue of respect for family life, interference, into the state's jurisdiction. But you'll only look at it, the interference, what the positive obligation requires, from the perspective of the person who's here. So the function of the jurisdictional link is to bring the family life into the jurisdiction, but it does not make the person abroad a rights holder. This case is completely inconsistent with that, because there's nobody here.
But the rights holder,
Yes, is outside the UK.
it doesn't matter if he's outside the UK or not. He was in the UK when he acquired the rights which are being protected.
It makes all...
I mean,
Right.
the thing that bothers me is that it's not just a question of rights. The rights are established by Article 8.1. It is a question of whether there's been an interference at this stage. We're only concerned with Article 8.2 and the proportionality exercise.
Yes.
So if you look at Article 8.2
Yes.
and see what it says, because that's, as I keep on saying, quite important.
Yes.
It says, there shall be no interference by a public authority with the exercise of this right, except such as in accordance with law.
Yes.
And everyone who has the right to respect for his private and family life is the sponsor, but the sponsor's private life, so family life, is enjoyed with people outside the jurisdiction.
Yes.
And what Sir James says is that you have to consider whether there's been an interference, bearing in mind that the family life may be unitary, but the person who has the right is the sponsor.
Right. Okay. So we say that's wrong.
I mean, I see a bit of nodding from the
Yes.
second
But-
row. So I'll take that.
The point is that when you get to 8.2 stage, the only rights that are relevant are the rights of the rights holder. I accept that. Of course they are. Right?
Right.
The issue is who's the rights holder. And Sir James says it's the sponsor. Right? But let's say, and you're saying, my lord, to me, that Ali doesn't help because the sponsor, the individual was here before. So what? With respect, he's now outside. In the family life context, let us say that somehow this family came to the UK, lived with my client, had a family life here, went back, October 2023 happened, and then they say, look, you've got to look at our family life from, in all the circumstances, with the history, we were here before. Would that make a difference to the analysis? Absolutely not. The key thing is that at the relevant date, who is within the jurisdiction? And in the family cases, the sponsors in the jurisdiction, but the effect of the family life is to bring into the jurisdiction the people abroad in the same way that in a private life case, there's nobody in the jurisdiction. No one. Yet, the established private life, doesn't matter that historically the person was here, it just doesn't matter. He's not there now. You ask, is this person not, was he in the territory? He's not. Those are my submissions. I don't want to labour the point.
No, okay.
By repeating
that.
So those are the 3 points I wanted to make on the domestic authorities. The Strasbourg authorities, we respectfully submit, Sir James misreads. Now, can I ask you to go to MN, please, which we looked at. So you'll recall this was the case about Syrian nationals in Lebanon seeking visas to go to Belgium and apply for protection. So MN is tab 57, Grand Chamber. This is a case in which Sir James appeared with the then attorney at 1544. The relevant passages that I want to take you to are, you've already been taken to 100, where I think I made a reference to the fact that the drafting was changed from residing within territories to within the jurisdiction. If you look, please, at 107, so the court says procedural circumstances have been used to justify the application of the convention in relation to events which occurred outside the respondent's territory. Thus, with regard to civil proceedings for damages brought by the applicants before the Italian courts under national law in respect of the deaths of their relatives as a result of airstrikes carried out by NATO against the Federal Republic of Yugoslavia, the court held, in spite of the extraterritorial nature of the events at the origin of the action, those proceedings fell within the jurisdiction of Italy, which was accordingly required to secure in those proceedings respect for the rights protected by Article 6. That's Markovic. More recently, with regard to deaths which occurred outside the territory of the respondent state, so the relevant event is outside the territory, the court found that the state in question had begun a criminal investigation into those events. That established a jurisdictional link for the purposes of Article 1 between the state and the victim's relatives. The jurisdictional link is all about someone outside the territory coming within the jurisdiction because there's a sufficient connection to establish that link. So it's nothing to do with the person who's here. And then if you look at 109, we've obviously looked at this carefully, Mr. James' assumption. By way of comparison, the court emphasises that the above cases are to be distinguished from those in which the facts contained an international element, but which didn't involve extraterritoriality for the purposes of Article 1. The situation of Article 8 cases concerning decisions taken with regards to individuals, irrespective of whether they were nationals, who were outside the territory of the state within which the question of that state's jurisdiction hadn't arisen, given that a jurisdictional link resulted from the pre-existing family or private life in that state. Now, here, what's important is that whilst in the cases they cite, there isn't an argument, they are approving what happened in those cases by reference to the existence of a jurisdictional link. So Nessa, it is a case, Nessa you have at tab 45, 11, page 1158. So the applicants were a woman resident in Finland and her relatives who were resident in Bangladesh. And they said refusal of visitor visas to Finland breached 3 and 8. The court found inadmissibility, but approached it on the basis that the people in Bangladesh, their rights were engaged. It referred to links with links with persons residing in Finland, which could be considered as constituting the family life of the people in Bangladesh, and concluded that the refusal to permit non-national persons to enter a country in order to visit their family members can't be regarded as infringing their right to respect for family life. Now, I accept there's no analysis. This is one of the cases where there's no analysis. But the fact that it's cited...
Where are you reading from?
From Nessa at page 1163.
Ah, thank you.
Sorry, I've gone too quick. 1163.
Paragraph, penultimate main paragraph.
Indeed, yeah. Penultimate paragraph. So, Nessa on its own, so James can say, well, no analysis, but there is clear analysis in MN, and it approves Nessa, and it's referring to the people, the approval we submit is referring to the people who were in Bangladesh. And similarly, the case...
It depends who the word there refers to. If it could be loose language referring to all of them.
Well, that's enough for me. As long as it's not the person in Finland. That's all I need.
Well, I mean, it could just be that they're referring to the unitary family, right? And not distinguishing because it's not important. They say because they had very substantial links. I mean, it doesn't help you on the main point because they've got very substantial links with Pakistan or wherever the other country is, Bangladesh.
Bangladesh, yes.
They
Yes.
can't be regarded as having their family rights infringed by being
Sure.
excluded from Finland.
No, but we're in ground two, and on ground two,
Yes.
I struggle to see how the refusal to permit non-national persons then to enter a country in order to visit their family members can't be regarded as infringing their right to respect for their family life.
Okay. Yeah.
It's pretty clear it's them.
Yeah.
And then that's endorsed in para 109 of MN. They also, the Grand Chamber also looks at Orlandi. Orlandi is at tab 56. And this case was about gay men challenging Italy's refusal to register their marriage. You see this from paragraph 3. Refusal to register their marriages contracted abroad. And more generally, the impossibility of legal recognition over their relationships. We see from 25 to 32, paragraphs 25 to 32, pages 1483 to 1484, that two of the couples were living wholly outside Italian territory, Canada and the Netherlands, when they sought to register their marriages, and also at the time of the applications. You cast your eye 25 to 32, and also 42 to 53 at page 1485. Then at paragraph 147, 1509, the court finds the application admissible at the top of the page, and at 211, this is at page 1524, at 2112, it finds violations of Article 8 and Article 8 or 12 plus 14. There's a dissent at page 1543. You see the dissent. At paragraph 13, the question that you see the end of that, two judges dissent, the question whether these applicants remain with the jurisdiction of Italy within the meaning of Article 1 hasn't been addressed. So, majority, we say, were aware of the jurisdictional issue, except Sir James can say, well, the analysis isn't there. But then when that is endorsed by the Grand Chamber, when it does give analysis, we say that's another powerful basis for our reading of Para 109 of MN. I should have said something about Al-Skani. If you remember, Sir James said dividing and tailoring is very specific and fine in this case. He explained that in the armed conflict contexts, the government were worried about extraterritorial application lest they had to guarantee free and fair elections. So James, I think, the phrase he used to use is people can't be expected to carry the ECHR with them into Iraq, I remember. Sorry if that's slightly loose, but you get the idea. This is simply another example of dividing and tailoring. In the Iraqi context, where you had state agents or authority, the relevant right was Article 2, life, Article 3, ill treatment. In custody, the relevant right would have been Article 5. Subject, I think Al-Jeddah established that. But certainly not free and fair election. Here, you divide and tailor by reference to the jurisdictional link, i.e. family life. It is why Article 8 applies, but not Article 2 or Article 3, because the jurisdictional link for Article 2 and Article 3 isn't there. But it absolutely is there for Article 8. So there's no dividing and tailoring problem if you understand that you divide and tailor by reference to the jurisdictional link in issue. So those are my submissions on law on ground 2A, why we say that there is the respondents are within the jurisdiction for the purposes of Article 1 because they have a jurisdictional link with somebody who's here. 2B, it just doesn't matter. We see that from most clearly from the Hyderi case. If you remember, your lordship, my lord, Lord Justice Dingemans alighted on this in argument. Hyderi is at tab 48. Page 1197. And we see, this is one of the cases where the jurisdictional point is made, if you remember, and the court says, well, it just doesn't make any difference. We see at the bottom of page 117, the facts: Afghan family who fled the Taliban, one mother and son were in the Netherlands, 3 other children in Pakistan. The initial decision, skipping a page of the minister under Article 8, set out at page 1200. The mother, essentially in the Netherlands, lacked sufficient means of subsistence. And the judicial decisions in the Netherlands are summarised at 1202 to 1204, upholding the minister's analysis. the complaint is set out at 1206. Netherlands disrespected Article 8 rights, refusing to grant a provisional residency visa to the 3 in Pakistan. And then the jurisdictional objection is raised by the Netherlands at page 1206. They cite Bankovic at the bottom of the page. And then they say that the state of the Netherlands had merely exercised its day-to-day responsibility for the regulation and control of the entry into its territory of aliens, to infer from such acts a direct responsibility of the state for the protection of the rights enshrined in the Convention to all those residing abroad wishing to enter the Netherlands would be, according to the government, extend the notion of jurisdiction to an unacceptable level. It's the end of the first paragraph, 1207. The court looks at this issue, passage you've seen at 1208. The court considers that as regards the family life at issue, the existence of which isn't in dispute, no distinction can be drawn between the 2 applicants within the Netherlands and the 3 others currently residing in Pakistan. These circumstances it doesn't find it necessary to determine the jurisdiction argument. So the logic appears to be that once the family life is established, the proportionality analysis has to be conducted by reference to the family unit as a whole, without distinction as between individual constituent members. So no distinction to be drawn in respect of the so-called lens through which one approaches the proportionality analysis. And that approach finds very strong support at 1209 in the second paragraph, because of the reference to the need to examine the mutual interests of the applicants, and the need to look at interference from the point of view of both sets of family members. Could you please just cast your eye across that paragraph, page 1209, second paragraph. And the key phrases are mutual enjoyment, 6 lines up from the end of the paragraph. It may be unreasonable to force a parent to choose between giving up a position which he's acquired in the country of settlement or to renounce the mutual enjoyment by parent and child of each other's company. The issue must be examined not only from the point of view of immigration residents, but also with regard to the mutual interests of the applicants. So that's directly inconsistent with the idea that if we're wrong as a matter of law, it makes a difference. It doesn't. You've still got to look at the issue by reference to the mutual interests of the applicants. That's people in Pakistan as well. There's no dropping off the 3 people in Pakistan when you're looking at interference. So we say Hydri is an important case on our alternative submission. So unless, my lords, my lady, you want me to say anything else? You've got any questions, sorry, on round 2. Those are my submissions on ground 2.
Can I just ask how one approaches it? Family life normally is company. We understand the family life was found to start from October 2023 for obvious reasons, and consisted of telephone calls, important telephone calls, and very important financial support.
Yes.
how does that feature in relation to rights outside and inside the jurisdiction? When it's not mutual support that needs personal contact, but is financial support?
It's mutual interests. The phrase in Hydra is mutual interests. So once you've got the unit, once you've got the family unit in jurisdiction, which any view we have, you then look at the mutuality of interests, i.e., I suppose what one would do is look at the rights of the sponsor and the interests of the respondents.
Thank you.
But the interests of the sponsor of the respondents don't suddenly drop out of the analysis. That's the fundamental point. If they did, that paragraph in Hydra is impossible to understand. So unless there's anything, I wanted to move to ground 3.
Thank you.
So ground 3, my lords, my lady. Schwidler. With great respect, the Secretary of State's case on Schwidler, we respectfully submit, is unsatisfactory insofar as there isn't a case. This is an appeal. There isn't a submission that's advanced. This is an appeal brought, pleaded throughout, on the basis of error of law in the classic sense, consistent with the review approach in Schwidler, including on ground 3, proportionality. Of course, we accept that Schwidler contemplates a different approach in some of the appeal cases, the fresh assessment, but it also makes clear that that approach is exceptional and has to be justified by special factors. The Secretary hasn't sought to amend her grounds, make written submissions, or even make a case orally for why that is appropriate here. So we are here today responding to a case as pleaded based on error of law, which is really, with respect to all we have time to do. Sir James suggested that you might go away and decide fresh assessment was appropriate in any event, and presumably then you make that assessment. But that would be inappropriate, we submit, because we would at that point need the opportunity to address the proportionality issue afresh, make a full positive case on proportionality, and that looks very different to a responsive case on error of law. Particularly so, my lord, where you've, we're very grateful for the fact that you've indicated that this is a very important case where full submissions need to be heard on all contested points. So we submit that the court should proceed on the basis of a review approach. And if there's anything else in contemplation, we would respectfully ask that you make that clear to the parties, and then we hear submissions on what's appropriate. It's a very different task that you would have to perform in a case like this, where credibility, oral assessment...
Well, that's what the UT did.
Sorry?
They remade the decision. Why couldn't we?
They heard evidence. They heard,
UT?
yes, absolutely, made credibility findings.
Who's that? Did they just hear evidence from the sponsor? Got a feeling it was just the sponsor, it was nobody else.
Yes. No, you're not going to get a video link into Basel.
No, but whatever, but that's the only person they heard evidence from.
Yes, and that's obviously pretty critical because...
But I mean, just asking the question, why? I mean, we've got lengthy affidavits from the sponsor.
Yes.
And we would, I assume, have to accept the evidential findings that he was a plausible and good witness.
Yes.
Why can't we then take that all into account and remake on the correct legal basis, if there is an error of law?
Well, because oral evidence
We
is...
do that every day in this court.
Yes, but this is a context where the oral evidence is very important for reasons I gave before. Laing, paragraph 15, and the Strasbourg case, paragraph 73. Dingemans.
We'd have to accept he gave compelling oral evidence.
It would be the classic, if it could be done. If there was a disputed fact, of course that has to go back and be determined either FTT or UT.
Yes.
But if there's no disputed fact, which I think is what my lord is putting to you, then this court can say we would carry out the review, accepting the findings of fact in your client's favour.
Yes.
Below.
Yes. But one asks a rhetorical question: why is it that the Upper Tribunal decided to hear evidence? Why didn't they just do the same thing?
There was a procedural failure of
Yes.
which was part of the reason that the judgment was set aside, because for reasons which are completely not apparent, neither side looked at 117b, which
Yes.
is bizarre.
Yes.
But anyway, is what happened. So of course you had to have evidence again.
Because there was an issue about financial support.
Yes.
So that's why they had to hear evidence.
Well, my submission is that even if it wasn't that, the appropriate thing for them to do in these cases is to hear evidence.
Well, can I just, so that you can deal with it, very frequently they say, when they set aside a decision, we preserve the findings of fact below, and then we'll remake the decision. Yeah. And sometimes, in this case, they had to, because there hadn't been fair notice given of the issue.
I entirely accept that. No, I entirely accept that.
Yeah.
The difference is, if you've got... Yes, this is Mr. Fakuri again reminds me of Biogen. You'll be well aware of it.
Reminds you of what?
Biogen.
And assessments.
Yes, Lord Hoffman, need for appellate caution, reversing trial judge because specific findings of fact, even by the most meticulous judge, inherently incomplete statement of the
Can't
impression.
hear a word. Sorry, you're gabbling and you're not.
I'm sorry.
Speaking up.
I'll slow down and I'll speak up. It is because specific findings of fact. So the need for appellate caution in reversing the trial judge's evaluation of the facts is based upon much more solid grounds and professional courtesy. It's because specific findings of fact are inherently an incomplete statement of the impression which was made upon him by the primary evidence, penumbra of imprecision and so forth. But the point here is you may have cases, protection cases are classic examples, where you've got the facts found by the tribunal below, first tier. They go wrong somewhere. The tribunal says Upper Tribunal says there's an error of law, and they apply the facts that are found to the objective circumstances. But that's not what this involves. This case involves an assessment and evaluation of the strength of family life. We accept that absolutely it's not binary. Once you're in family life, it's the weight you allocate to it is not constant. It turns upon the strength of those ties, and the court that hears the evidence enjoys a significant advantage.
Well, let me be clear, speaking only for myself, that I would not be minded to give any indication now as to how we will deal with the matter. Sometimes, having written judgments, we decide to remake the decision on the facts found below, and sometimes we send the case back. But for my own part, I'm not telling you now how,
in due course,
in that event, because we've got to go over a lot of hurdles before we even get there, we're certainly not guaranteeing that there will be another hearing at which evidence would either be heard or directed.
I hear that, my lord, of course I do. But I would like to address ground 3, the pleaded ground 3. Schwidler is not a straightforward case.
Well,
and
Sir James said we didn't get to Schwidler.
Oh, okay.
I mean,
then I don't have to do.
He didn't say we could never get to Schwidler. He said we probably wouldn't get to Schwidler.
But if you do, then I would like to make submissions on why it's the Schwidler fresh assessment approach is not appropriate. But at the moment, there's no positive case advanced by the Secretary of State that it is appropriate in circumstances where the very strong default position is the normal one, review. That's what I'm trying to say.
Okay, well, we've got that submission.
So ground 3, in the time I've got now.
I mean, you've dealt with a lot of ground 3 because you
Yes.
say, you took us to the decision-making sections and you said they were careful not to go overboard on the issues that were relevant as you've argued they were.
Yes.
I mean, you have to deal with Sir James's main point, which is that what drove this decision was ignoring immigration policy and therefore the words of Article 8 to itself.
Well, we respectfully submit that the tribunal did no such thing. Can I please take you to the tribunal at page 110, paragraph 92. 92, page 110. So this is this is carried forward into the remaking. But so I'm taking you to this in order, if you like. The judge was plainly entitled to have regard to the inability to meet the rules which were in place. It is well established that this is a consideration deserving of considerable weight at a general level in the balancing exercise. See, for example, Supreme Court in Aguiarco. The rules reflect the executive's policy, which in turn is the means by which the public interest is, at least to an extent, represented. In addition, the rules are endorsed by Parliament, by negative resolution procedure, so they have a wider legitimacy. That's standard stuff, and in impeccable self-direction. They're well aware that considerable weight, adverse considerable weight, applies. And then if we go to page 123.
Well, I don't quite understand it. They say the judge materially erred in law, and then they say in 92 the judge was right.
Well, that's because they go on in
Yes.
Yeah.
the succeeding paragraphs to say it was wrong to place weight on the fact there wasn't a resettlement scheme,
Exactly.
in short.
Exactly.
Yeah.
And thank you, my lady. They say he wasn't considering a resettlement scenario if he thought the whole case amounted little more than a contrived attempt to obtain resettlement through the back door, would have been open to find against the appellants. He didn't. The statutory scheme combined with well-known authorities on the correct approach to appellate jurisdiction required him to follow a conventional step-by-step route through the proportionality exercise. Once the gateway had been crossed, it was for the appellants to demonstrate exceptional, compelling circumstances or a very strong case. Those are terms used by Lord Reed in Aguiarco, where you've got you're outside the rules. And they say that again at page 113
Lord Reed in what?
in Aguiarco.
Aguiarco.
Then they remake the decision, sorry.
Their view in 95 is that the absence of a resettlement scheme is irrelevant.
Yes, because they treat it of neutral value because otherwise you double count. You're outside the rules, and resettlement schemes are outside the rules. So the absence of a resettlement scheme isn't somehow an extra factor to be weighed in the same way that if you were seeking entry from Pakistan and you were outside the rules, you wouldn't be open to a court to say, well, there's no special scheme for Pakistanis. You're just outside the rules. And they also made the point that there wasn't any evidence about a deliberate decision. I mean, I don't put my...
That's a really weak point, isn't it? There's either a scheme or there isn't.
Yeah, there's either a scheme or there isn't. And you're either in the rules, you're not in the rules. Think of it this way. If there was a scheme, my lady, and you were outside the scheme, you'd be in a difficult position because you're outside the rules. This is the Windrush context. You're outside the rules, and then you're outside the scheme that's just been created outside the rules. That's not the position here. You're just outside the rules.
Well, I mean, you talk about the scheme being outside the rules, but the schemes get incorporated in the rules. And I think the point that, as I understand it, the First Tier Tribunal judge was making was you're outside the rules, and there isn't even a scheme set up as there was in Ukraine.
Yes.
And therefore, it's different. I mean, whether it adds very much is a different point. But
my submission doesn't add anything because analytically, the position is you're just outside the rules. So, and then at 140, so this is in the middle of a remaking of the decision. At 140, they say, we direct ourselves that in order to succeed, the appellants are required to make out a very strong claim, or what might otherwise be described as a case disclosing very compelling or exceptional circumstances. Again, those phrases are Lord Reed in Agiolka. And then they find that standard is met at paragraph 182. Having said, sorry, before I get to that, 151, page 124, they must instead meet a very demanding test. That's 4 lines up from the. Sorry, I said 152, 151, 4 lines up from the end of that paragraph. And 182. Having conducted what we say is a multifactorial exercise, rejecting Mr. Kiriko's submission that conditions are enough, look at everything else. Of course, conditions in Gaza attract considerable weight. How could they not? Come on to floodgates in a moment. At 182, they find that on the having addressed all the considerations identified by the parties being relevant to the proportionate exercise, attributing varying degrees of weight to each, we conclude that the respondent's refusal to collective human rights claims does not, in the particular facts of these cases, italicized, strike a fair balance. On a cumulative basis, the weight we attach to the considerations on the appellant's side demonstrates a very strong claim indeed. Another way of putting it, there are very compelling or exceptional circumstances. Even in the absence of a resettlement scheme, if that were a relevant consideration, the weight we would attach to it would have made no material difference. That's belt and braces. So we say it is, in terms of self-direction, there is nothing to the point that they did not understand the strength of the public interest. They directed themselves by reference to an exacting standard.
Can I ask you where in the proportionality analysis, if anywhere, the strength of the family relationship goes? Because there is obviously a difference between a young child being left in Gaza on their own and a link with a brother that, for understandable reasons, you've not seen for a long period of time, and his family. Should that form part of the analysis?
Yes, it does. Yeah. Absolutely, it does, because what's involved in deciding whether the interference is necessary in a democratic society for the non-legitimate aims, economic well-being, protection of the rights of others, is a fair balance between the individual's interests and the community interests. So if the scales on the individual side are not as heavy as they would otherwise be, then that absolutely is relevant. The second way that the Secretary of State put it in terms of public interest is the interiorum argument, floodgates. And we make a number of points here. I make 4 points. The first point is that Article 8 cases in the Upper Tribunal do not create factual precedents. They are intensely fact-specific. The courts have repeatedly emphasised that the value of comparison with similar fact scenarios is very limited. You'll recall this court saying that. There is no read across. As the Upper Tribunal said, our task, this is page 124 at para 153, our task is to assess these cases on their own particular facts. And we say that the analysis of proportionality, the multifactorial analysis as to proportionality, did precisely that.
But in reality, Mr. Hussain, surely if an appellant pitches up in the First Tier Tribunal with a similar claim, the appellant's going to rely on this case, isn't it?
Well, it's an unreported decision, so you're not allowed to rely on it without the tribunal's permission.
Right.
Mr. Bondock is very experienced in these matters, as I once used to be, has indicated, helpfully indicated that unreported UT decision isn't binding on the FTT on issues of fact.
Right.
More complex as to whether it's binding on issues of law. Factual precedents in our legal system were once described by Lord Justice Laws as an exotic concept. Don't have factual precedents, save where there's legislative authority for, in the tribunal system, for issuing country guidance decisions. There is that legislative authority. This is not a country guidance case.
What are the other 3 points? Delay does not create factual precedent. Second,
the evidence about floodgates was and remains exiguous, and the inferences are speculative. And we address this in our skeleton from paragraph 77 through to 79, where we make the point that the tribunal made it clear that even if that argument was capable of relevance, it made no difference on the facts, because the figures available didn't support the contention that applications from Gazans represent what might in principle be described as a floodgate scenario. It was certainly not 4,000. It was in the hundreds, and sorry, it was 118. Eventually, we get to that. You'll recall. And the tribunal also said at 154 to 156 that the claim was speculative and misconceived. No error of law is identified in that analysis. The criticism is, in the skeleton, that the tribunal erred on the facts of the case. that doesn't take her anywhere because the tribunal said that the evidence didn't support the idea that there would be, to use the vernacular, floodgates.
Can I just ask a question about that, please, Mr. Hussain?
Yes, of course.
How can you have evidence about something that might or might happen, might not happen in the future?
Well, you could point to people having making claims in the past. I mean, I'm going to come on to the case of Killer in a minute, which addresses this.
Okay.
Because what you might think is that the court should defer to the Secretary of State and say, well, we're very concerned about what you've said. That was Lord Brown's view in Killer. The majority rejected that. The majority said you've got to interrogate the material. It was a cognate concept. I'll come on to that in a minute. The material that was provided belatedly, Mr. Ramsbottom, we addressed this at 79 of our skeleton. Sorry, forgive me. 79 and 80 of our skeleton. Mr. Ramsbottom, the first point we make is that he explains the Secretary of State is aware of simply 22 cases involving 112 people. No material change from that before the UT.
But I think my lady's point is this is not just about Gaza. This is about all war zones, of which there are many in the world, and people who are either being persecuted or are living in extremely terrible conditions and at severe personal risk in foreign countries. And what the Secretary of State is saying is, even if there is family life, one factor to be weighed heavily in the balance under Article 8.2 is the public interest of people here to control immigration. And that there may be many, and we don't know which war zones there'll be in the future, and we don't know what other terrible things will happen. We know terrible things have happened in Afghanistan, in Ukraine, and in Gaza. But there may be many more. And if the balance is struck in the way it was struck here, what's said against you is that there may be, the balance may be struck the same way in many, many cases.
Well, I appreciate that's what's said, but it ignores the intense specificity of the case. If you're not with me on that, what I would say is that what the Secretary of State is effectively arguing for is a judicial dampening of the Article 8.1 right, if not a judicial carve-out for war zones.
Well, I just don't get that. There shall be no interference by a public authority with the exercise of this right, except such as is in accordance with law and is necessary in a democratic society in the interest of the economic well-being of the country, or for the protection of health or morals, or the protection of rights and freedoms of others. The judges have to give effect to that and decide the balance that subsection, subarticle, provides, don't they?
Yes, but
So you can't accord no weight to the protection of the rights and freedoms of others.
Yes, but you've got to have a secure evidential basis we submit for doing so. Can I take you to killer? I'm going to come on to my fourth point, which is why, or maybe, can I make the fourth point now?
Okay.
Which we say that the point is bad in principle because of the incredibly concerning result that it yields. The result that it yields is that the worse the conditions, the more generalised the conditions, the weaker your claim to escape from it when you have a family life. That's extraordinary. So let's say you've got a risk of death in Germany and family life would be extinguished because there's a refusal of interclearance, and you weigh that very significantly in the balance. We don't grant interclearance, the person will die, that will extinguish family life. Here, you've got exactly that situation, but because the risk is faced by very large numbers, that somehow diminishes the weight that you give to the individual's interests in the balance. Now, your lordship talked about the moral concern for others. I showed you a passage from Mr. Justice Mundy about the court's constitutional role in protecting the rights of minorities, particularly the rights of those who are disenfranchised. So Rabinder Singh wrote a book a long time ago, and he made the point that the largest client group in Strasbourg used to be gays, prisoners, and immigrants, unpopular minorities who don't have the franchise. So this raises deep questions about what your role is in our submission. And the extraordinary consequence of my learned French submission is, as I said, the worse the conditions, the more widespread the conditions, the weaker your claim to escape from them. That follows, as a matter of logic, it's deeply unattractive, we respectfully submit. It would be a bad day for the courts to accede to that logic if the Secretary of State wishes to address these concerns. There are ways of doing it. Judicial policy making is not the right way. The right way of doing it is through normal executive policy making, with or without the imprimatur of Parliament. It's a startling position.
But you're
These people, sorry.
I'm so sorry, no.
I was going to say, these people facing a daily risk of death. Their house was bombed on 10 minutes' notice. There's a picture of the tent in which they last lived in the materials. They're in freezing conditions where children have died through the cold. There are issues with aid, and the court says, well, there's lots like you, probably, maybe, not just lots like you in Gaza, but lots like you in the world, in Sudan, and therefore we're going to discount that. Your Lordship made the point. My Lord Master Rolls made the point to Sir James. So you let in the risk of death. Sir James accepts that. But then to what end? You then discount it. That's a startling proposition.
Well, I mean, I know this is very emotive.
I don't think it is.
Nothing I say should be taken as being anything other than acutely conscious and sympathetic to the plight of these appellants and many others, not only in Gaza but elsewhere. But the question is not whether you take into account their plight, terrible that it is.
Yes.
The question is what is balanced on the other side? How do you evaluate it
Yes.
against other factors? So nobody is suggesting that you completely ignore the terrible situation in which these appellants find themselves. But and your submissions sound a little bit like, I think, what Sir James is complaining about, which is that it was said to be the driving force. Now, I don't think you really make that submission.
No, I don't.
I think your submission is it's a terrible situation that weighs heavily in the balance. There are other factors, including those mentioned in Article 8.2,
Yes.
and the balance
Yes.
lies in favour of the appellants.
Yes, but my lord, with great respect, you're straw-manning me. I did not say that this analysis leads to the proposition that you leave this desperate plight out of account. I didn't say that. So James says, no, you let it in. You've got to look at it. It's a relevant circumstance. But then you discount it.
Well, he didn't say that.
No, sorry,
He said
you
put it in
reduce
balance.
the weight. I don't mean discount as in ignore. I mean that you give it less weight. Because, why do you give it less weight? Because there are many people who are suffering as badly. It's a bad day, with respect, for human rights adjudication in the courts of this country, were the court to accede to that kind of submission. It's precisely the kind of consequence that the court, mindful of its constitutional role, Lord Brown said many years ago, the courts are the guardians of rights. You're not subject to the vicissitudes of political expediency. There's a reason for that. Basic stuff. What are human rights instruments supposed to do? So it's supposed to remove certain rights from those vicissitudes. If the government want to achieve that result, they have the means to do so. Enact a rule or a policy. You consider that Parliament should be consulted. Do that. Get parliamentary approval to copper bottom it. It's my submission. It's a very serious thing. I actually do not shirk for a second from the proposition that Sir James's submission amounts to this. The worse the condition, the more widespread the risk of death, the weaker your claim to get out of that once you have family life. That's very, very concerning. I wanted to take you back to the third point, which was the evidence by Lady Justice Laing. Killer, I said answer this. Killer is at tab 13. So Killer concerned a rule about deterring forced marriages, and the issue was whether it in fact did that.
Killer, tab 13,
Tab
page
13.
235.
Tab 13, page 235, yes. And so that's the issue. Would this rule, which prevented marriages from, increase the minimum age of marriage to 21, would it deter forced marriages? So obviously, forced marriages are a modern day evil, clear social good in doing that. And Lord Brown says, at paragraph 91, at page 273, the extent to which the rule will help combat forced marriage and the countervailing extent to which will disrupt the lives of innocent couples adversely affected by it is largely a matter of judgment. I think that's what my lady was driving at. Unless demonstrably long, this judgment should rather be for government than the courts. But he's in a minority of one. If you look at Lord Wilson at 44 onwards, he analyses justification And at 46, says Lord Brown's call, at para 91 below, for the courts in this context to afford the government a very substantial area of discretionary judgment is at odds with my understanding of the nature of their duty. Indeed, in Huang's case, Lord Bingham proceeded to explain it would be wrong to afford deference on matters relating to the above questions.
So sorry, which paragraph are you reading from?
46, sorry.
Oh, sorry.
Bottom 257, sorry. And then over the page at 48, Secretary of State's contention that the amendment is likely to deter forced marriages remains based upon the four bullet points including in a report. And then he interrogates those very closely in the succeeding passages and finds that at 54 that the evidence doesn't substantiate the Secretary of State's claim. It's an Article 8 case. You've got a fundamental right engaged. If you want to defeat that by reference to predictions about what might happen in the future and issues concerning general deterrence, you need evidence. The evidence is exiguous. There's no challenge to the tribunal's conclusion to that effect. And in this context, you need, as you had in Killer, a rule with democratic legitimacy, albeit through the negative resolution procedure. The only other point I want to make...
I'm so sorry to interrupt. What kind of a rule are you saying there should be?
A policy or a rule that in Gaza, I mean, let the Secretary of State say this, in Gaza, applications for entry clearance for family reunion, the tribunal shall accord little weight to the risk of death. Let the Secretary of State take the political cost of that, rather than inviting the judiciary to approve that sort of rule. And it's not emotive, my lord. These are submissions of principle.
Yeah,
they're based upon. Sorry.
I understand that, but I did put to you something that I'm not sure you really answered. That it's not being said against you that the terrible situation in Gaza has no weight. It's not being said against you that the worse the situation, the less weight is to be attributed. It is only being said against you that what has to be balanced is the other factors mentioned in Article 8, 2, and that one of those is the rights of others in this country. And so, I mean, in a sense, you're pushing at an open door, anyway, so far as I'm concerned, with the proposition that the terrible situation of the people in the position of the applicants is of great weight. But of great weight doesn't equal conclusive. It may equal conclusive, but there may be other factors too. And what I'm really asking you to say is how you balance the other factors that are in a statute or equivalent to a statute enacted by the Human Rights Act of 1998.
If I may say so, my lord's moral instinct that you take this very seriously. We have care for others.
It's obvious.
That concern is undermined not directly, it's not done directly, but the effect of the submission is that. And it's, again, with great respect, I don't mean to be rude to you, but you're strawmanning me again. I didn't say that no weight is to be given as a matter of on the Secretary of State's submissions. It's diminished.
No, but what I'm asking is how. how you do it,
Oh,
because you've got factors that affect.
one thing that you don't do is you don't say, a court, removed from the political process, I have this case in front of me, there is a risk of death, it's intensely fact-specific, got all these factors about English language, finances, strength of family ties, got the risk of death, I'll come on to best interests in a minute, so I'll close with that. What you don't do is predict on the basis of exiguous evidence that if I allow this case, somehow my case will become a factual precedent, my judgment will become a factual precedent, and there will be 4,000 people, in fact it seems to be far less. And therefore, I'm going to factor that in, not to give the risk of death no weight, but to reduce the weight that I give to the fact that these children and their parents may die any day. Another way of putting it is that the Agiaco rule of exceptional circumstances is not modified because it's Gaza, Sudan, war zone, to exceptionally exceptional. If the Secretary wants to achieve that result, and she wants the courts to diminish the weight to be given to the risk of death, then there needs to be a rule. And the rule that I suggested to my lady was not no weight, but little weight, because that's Sir James's submission. Sir James's submission is not no weight. His submission isn't that you don't take this into account. You take it into account, but then you offset it because of numbers.
Okay, I have it now. Thank you.
The only other thing I wanted to say was best interest. We cited a case called BI, which makes it very clear that it substantiates the point I made earlier. Strasbourg, Article 8, best interests of the children abroad are taken into account, and you have that. I'll just give you the reference to our skeleton.
What's the case called?
BI v Switzerland.
VI.
B for Bertram, if we're talking about morality.
Which tab is it?
Please just give me one second. Sorry, it's BF. BF and others v Switzerland. We address it at paragraph 39 of our skeleton. It's authorities tab 59, pages 1644 to 1647, paragraphs 119 to 125. Applicants were refugees in Switzerland, seek to sponsor family members abroad. 3 of them concern their children, whose other parent was either missing or dead. European Court has regard to the children's best interests by reference to the passages I gave. Those are my submissions, my Lord. Thank you very much.
Thank you very much.
I'll just ask one question, please. May I just ask you one question, please,
Yes.
Mr. Hussain?
Yes.
You told us that this decision of the Upper Tribunal in this case is not a reported decision.
No.
But if somebody searches the Upper Tribunal website, they'll find it, will they?
Yes, correct, but with permission, they could then cite it to the First Tier.
Right. So if you're a lawyer or an immigration practitioner or whatever, you could search Gaza and you'd find this case. Mr. Campos nodding vigorously.
Oh, it is
Well, I just wanted to check.
surrounded by expertise.
No, I just wanted to check what the position was. Thank you very much.
And I asked you a question after lunch. Did you want to give an answer to it, or do you want to think about it, or what do you want to do?
Do you mind if I think about it? I'm sorry.
Right. Well, if you're going to think about it, you're going to have to answer it pretty quickly.
Would you like me to answer it today? Can I have until tomorrow or not?
You can have till Friday at 4 p.m.
Thank you very much. Can I also, this two-pager that Sir James has put in at lunchtime, I haven't had a chance to look at it, make submissions. Again, could we please respond to that in 3 pages?
You can respond to it by Friday at 4 p.m.
Thank you very much.
Yes, Sir James.
My lady, back to ground 1, please. And the answer that we give to the question that my lord posed is that the Court of Appeal issue is against the refusal of the Upper Tribunal to find an error of law by the FTT. On this issue.
So that means that you advocate for the proposition that the FTT did make an error of law.
I do. And if they erred in that test, then the appeal is to be allowed, and the consequences follow, which now may not involve you remaking the decision in accordance with the correct test.
And sorry, say that again?
If that is right, your second part of your question, I think, was, does it follow that the appeal should be allowed?
Yes, and then you remake.
Exactly.
Yeah. Okay, thank you.
That's the answer we give.
The answer is yes.
The answer is yes. The answer is yes to both questions.
Yeah, thank you.
My lords, my lady, you'll know that in relation to ground 1, the critical feature we submit is what do you get about this issue from the case law in Strasbourg. You start with that case law, and to some extent you finish with it, because it's the key. All the courts are trying to apply the principles to be derived faithfully from that case law. And the case law we submit is about, and precisely now about, the principled approach to the headline test. You saw the references to S and the United Kingdom. I took you back through those. But it's what does that test mean? Elements of dependency going beyond the usual emotional support. What does that mean? And what you get from the case law is, consistently we submit, is both an emphasis on dependency and a complete absence of any formulation of the test as being support, clear, committed or otherwise. You just don't get that featuring. You get the S formulation recited, but it is dependency that is at its heart, and you don't get support. So the support is a gloss, a reading down, as Lord Justice Sedley, who seems to have started the trouble, as it were, put it. But you don't get that from any of the Strasbourg authority. What you now have in Kumari, and my learned friend had almost nothing to say about Kumari or indeed the 2 cases that followed it, which directly and specifically applied the principles in Kumari.
Well, he said Alvarado qualified it effectively.
He does, and I'm going to come to that. That's wrong. But what you don't get from those cases is any disagreement, those subsequent cases. Indeed, on the contrary, they're applying Kumari. And what Kumari does, and the significance of Kumari, is that it elucidates and is specifically designed to clarify what that concept of elements of dependency going beyond normal emotional support means. That's the very purpose of them doing the analysis of the cases that fall on one side of the line or the other. And they say so in terms in Kumari. That is, we submit, an entirely appropriate, well-recognised judicial approach, both in Strasbourg and in our courts, for seeing how a concept, a headline concept, falls to be applied in principle. This is not scrabbling around amongst the facts. in the case law to try and generate precedents from facts. They're deliberately not doing that. They are seeking to clarify the principled approach. In doing so, you will recall, they set out in particular a set of cases, some of which fell on one side, some of which fell on the other side of the line. And the significance of that for present purposes is that these aren't some outlying bunch of cases to do with medical conditions. They are indeed to do with medical conditions, but by definition, medical condition cases will fall at the top of the tree, as it were, in terms of seriousness, in terms of the support that is required from the broader family, precisely because there is a medical condition involved. And what they do, therefore, is to start from the premise that they're in that high territory anyway, in terms of support. And they say this line of cases shows you that that sort of thing does fall within the concept. That line of cases show that you don't. And the line of cases that show that you don't, the paragraph 39 of Kumari cases, are significant because I say they're all support cases. And the challenge that Kumari throws up, as it were, is to explain how, if real support is truly the test, which is where my learned friend got to, how those cases could possibly have been decided as they were.
So what he says in answer to that is that in PT Sri Lanka at tab 18, Lord Justice Underhill went to a lot of trouble to set out paragraph 60 and following from, I can't remember which one it was, but Singh or one of them, which summarised the ECHR authorities, which gave examples that were of a far lesser, what should we say,
Seriousness.
seriousness.
My lord, yes, but be a bit careful with that, because one of the cases cited, for example, out of that range, was the A.W. Khan case. Do you remember that was a separate one you were sent?
Yes.
And the relevant paragraph, so far as that is concerned, you will recall, I don't want to go back to it now, take up time, I took you to paragraph 32. That was the first in my run of cases that led you to Kumari. And so the first answer is, in relation to PT and that analysis of the Court of Appeal, is that they were centrally dealing with the question, is there a rebuttable presumption? And decided you don't need that, there isn't one. Then they cite a range of cases without truly seeking to address or indeed addressing the difference between dependency on the one hand and real support on the other. And they cite with approval A.W. Khan, which makes it entirely clear that the test is a strict one. And finally, and importantly we submit, the critical feature to bear in mind is that they did not have any of the three later cases that you now have, where the Strasbourg Court has gone out of its way to clarify what the right approach is in principle. But so the Strasbourg case law we submit that demonstrates beyond peradventure that the test is one of dependency, elements of dependency. That doesn't preclude it being a question that requires individual facts to be considered. Indeed, on the contrary, the court goes out of its way to say that the facts need to be considered in each case. What they're doing is to identify the key features in principle that bear on that concept, that S and the UK concept, and they do so in a way which we submit is extremely helpful. And you could ask the question in a slightly different way. Take any of the Court of Appeal decisions on which my learned friend has relied and ask whether they would have been phrased in the same way if the Court of Appeal had before them the three cases that you had before you. And our submission in answer to that is absolutely clear. Alvarado I did want to pick up because my learned friend said that it stands as authority for the proposition that exclusive dependence is not required. And he's correct about that, but the difficulty he faces is that that doesn't help him because he misconceives what that adjective is doing. It is not a description of the height, as it were, or level of dependence that is required, of the kind that was considered in Kumari. On the contrary, the point that was being considered in Alvarado and the reference to exclusivity was whether or not you needed to demonstrate that there was only one set of people in the world who could deal with the medical condition in question, i.e. the family members. The debate in that case essentially turned on whether or not the relevant authorities in that case had been right to reject the application on the basis that there were other people in the world who might just about have been able to care for the son's condition, namely the care system, I think it was in Peru, and the brother who'd never paid any attention and was travelling a lot because, as I recall it, he was a professional football referee, or the dedicated sisters who'd been looking after him for years. But the point I make is, if you just go back very quickly to Alvarado, tab 62, page 1709, you will see that very clearly. The rejection, go to paragraph 49, first of all, 1725. 1725, bottom of paragraph 79. Thus, it cannot be derived from the above-mentioned case law, as the authorities, that's the Dutch authorities, seem to assume, see paragraphs 15, 18, 22 above, in fact, it's that whole factual section, that exclusive dependency, they put in inverted commas, is always required in order to find that family life exists. But you'll see if you go back to the paragraphs what the debate was actually about, and I hope I've accurately described it. Look, for example, at paragraph 9 on page 1713. It was all about whether the institutions in Peru, the public institutions in Peru, whoever it may be, could have done it in combination with the brother or not, or it was the sisters. And you didn't have to demonstrate there was only one group of people in the world. That's what they're dealing with in terms of exclusive. They are not saying that exclusive dependency equals a strong degree of dependency. It's a fundamentally different concept. That's the concept that is dealt with and elucidated in paragraphs 38 and 39 of Kumari. The significance of Alvarado, just to take the point from this, go to 1722. I made the point in opening, I repeat it, but I repeat it by emphasising this. The court in Alvarado, under the heading General Principles, which sits above paragraph 35, recites absolutely in terms exactly the paragraphs that we went through in detail in Kumari.
Sorry, at page
At page 1722, you see the title General Principles above paragraph 35?
Yes.
So these are general principles. They're trying to elucidate what the general principles are for dependency in the context of adult family members' relationships with each other. And it isn't just excusable by virtue of the fact that this was the same section, so why wouldn't they? Because when you get to Demirci and Hungary, which is the next case, tab 63...
Well, I mean, just at 38 there, it's useful to see that the court again repeats in Demirci the finding at the bottom of the page, the finding of the existence of family life based on additional elements of dependency other than normal emotional ties.
Yeah.
Will often be the result of a combination of elements.
Yeah. Oh, yes. And then it goes on, as you will recall. I'm not going to go through the paragraphs again because we went through the identical paragraphs in Kumari. You'll then recall that it seeks to elucidate what that means by reference to certain cases. Look at the last two words of paragraph 38 that you just referred to, by way of further clarification. And then it sets out my 38 and 39. In this case, it's 39 and 40. But they're the same thing. Citing A.W. Khan and all the rest of it. And then when you get to Demirci and Hungary, you end up in a place where they are simply applying those principles. If you go forward to page 1741, paragraph 70, this is a different section, and they say they've recently summarised it in Kumari, to which can be added Alvarado as well. And they set out the reasoning, and you'll recall that I took you to paragraph 74 of 1742, to make good the proposition that they were faithfully applying that paras 38 and 39 distinction in Kumari. So that's what we say about the Strasbourg case law. So far as the domestic cases are concerned, we do submit that the case law appears to have departed, as it were, faithfully from the Strasbourg case law, even as it then was in the judgment of Lord Justice Sedley in Kugathas, reading down, as he put it, the Strasbourg test, which he had previously accepted accurately, was summarised in S and the UK. And I made the point in opening, and I repeat it without going back to it, but none of the cases, not one of the cases which he cited as justifying the references to real and committed and the real existence in practice of close personal ties and all of that, none of those cases supported any departure from the S test. They were all, as I pointed out in opening, about close family ties within the core unit of the family, and they were not considering the issue which this line of case law is considering, namely the relationship between adults. I pick up the suggestion in some of the Court of Appeal case law, Singh is 1, tab 3, paragraph 20, that there's some form of test that focuses on the real existence in practice of close personal ties. That is an essential ingredient of family life, and indeed was the jump-off point, you might wish to note for your notes. It was the jump-off point in paragraph 34 of Kumari, the opening paragraph under the heading General Principles, where they recite that principle. But it is evidently not the end point. It's a necessary but not sufficient condition when you're analysing the relationship between adults, because the rest of the judgment in Kumari and all of these other cases indicates that you don't just stick with that test. When you're dealing with adults, more is required. What is required? Dependency, elements of dependency going beyond the ordinary. What does that mean? See Kumari. And so our ultimate submission is, or I should just pick up Beku Betts, if I may, or two other points perhaps before I get there. Beku Betts, we say additional elements of dependency is the test. That's the formulation which the House of Lords in that case applied, and we respectfully submit correctly. The rest of that judgment is simply application of that test to the particular facts, and we would add, without the benefit of the elucidation of how it's meant to work, that we now have in Kumari, but it certainly doesn't operate to bind you, as it were, to bring you outside the principle in RJM. The second point to emphasise is that this can't all be dismissed on the basis that this is all about the facts. Everything's about the facts. We don't need to worry about any of it. It's just about the facts. And/or, that seems to be allied with a submission that says, real support, my learned friend's bottom line, is to be treated as being the same as the test in Kumari. But with the greatest respect to him, that is completely untenable. The proof of the pudding is in the FTT at paragraph 25. But we respectfully submit that on no view is a test that requires elements of dependency, meaning the sort of thing that was analysed in Kumari, without going back over that, can remotely be equiparated with real support. It plainly imposes a much stricter test, and for all of those reasons we submit that there is a clear and consistent line of authority in Strasbourg from S onwards, but we don't necessarily need that, because what is absolutely clear now is that Strasbourg has gone out of its way to clarify what that concept means in Kumari and the following cases. And so if and to the extent there has been a change, we respectfully submit that RJM covers that. This is about a point of principle. This is about the correct principled approach to that headline concept derived from S and the United Kingdom. Alternatively, we submit you cannot be fully confident that Strasbourg will do anything other than apply the approach in Camari going forward, and that's sufficient for our purpose too. Ground 2, very briefly, if I may. Whose rights? MN, let me just go back to MN and Belgium, tab 57. And the critical paragraph, as you will recall, is paragraph 109. And the key features of paragraph 109 to bear in mind are that the position that they are dealing with is one in which there is no extraterritoriality. So they're referring to a territorial link. And the jurisdictional link that they are referring to in the Article 8 cases is the jurisdictional link to the family in the territory. That's why it doesn't involve extraterritoriality, because you've got the link to the people in the territory, namely the family who are present there. That's what the state party had a duty to protect, precisely because the person falls within the ordinary conception of jurisdiction that they'd earlier identified and derived from Alskany and Bankovic. Well, then friends seem to say that there was no need to refer, there would have been no need to refer to the jurisdictional link at all if they were only dealing with rights in the territory, but that's simply wrong. What the court was doing, what the Grand Chamber was doing in MN, was explaining that the case in question, these Article 8 cases, were not cases of extraterritoriality, precisely because the link in question that founds the jurisdiction is the ordinary common territorial link, creating the right for the person on the territory of the contracting state. It does not say, as it could have done, certainly it does not say, the family members outside have rights. Or more accurately, the state is obliged, under its positive obligations, to accord Article 8 rights to them. And the judgment in Nessa, which they cite, to take that as an example, simply doesn't assist my learned friend. The point wasn't raised or argued, it was disposed of as admissibility on the merits of the Article 8 claims anyway, but in that case there was a person in Finland who had Article 8 rights, in other words, the granny. So, as it were, Nessa cannot be support for the proposition. And so far as Orlandi is concerned, and we would add is not inconsistent with our reading of 109, so far as Orlandi is concerned, you'll recall that Orlandi involved people who had been in Italy and who then, when they returned, I take that language from paragraph 191, had their rights to have their marriages registered refused in Italy, so that you were dealing with rights in the Italian territory anyway. So it's a bit like perhaps the Markovic cases, where you've actually got some proceedings or some rights in the territory itself. But so far as that is concerned, you've got both the personal link to the Italian state when they returned, para 191, and you've got rights which are in Italy.
And in each of the marriages, at least one of the parties to the marriage was an Italian citizen.
One of the marriages was?
One of the parties to the marriage was an Italian citizen, at least one of them, and in fact in most cases.
I think in almost all of them.
I think one of them may.
One of them may not have been, but my lady is right. Yeah. So those features existed, but none of that leads to a different reading of para 109 of NN. So far as materiality is concerned, why does it matter whose rights they are? Well, I've dealt with that in some detail in opening. I don't want to take too much time on it now, but so far as the position there is concerned, and whether it matters or not, we do remind you about the second half of the Upper Tribunal's judgment, the second half of paragraph 166. So the analysis of the factors in the appellant's favour is preceded by an express finding that they do have themselves Article 8 rights. And they rely on Al-Hassan and so on, overturning the KF decision, which I'm not going to go back to. But the Upper Tribunal evidently regarded that as a significant point. You know that our submission is that even if we're wrong and they do have rights, you still need to focus on Article 8. It's Article 8 that matters here. You can't drag in Article 2 and Article 3 through the back door. But our primary case is that when you properly analyse who has the rights, the relevant rights are the rights of the sponsor who is within the territory, not of the family members, and that is of some significance for the reasons that I gave in opening and don't repeat. Just to pick up one other point on Haydari, which my learned friend relied on to attempt to show that this all doesn't matter, doesn't make any difference anyway, where the rights reside. We respectfully disagree. But Haydari does not stand for the contrary proposition. It's at tab 48, I don't invite you to return it up. The points I do invite you to note on Haydari is that it didn't matter in that case. They deliberately didn't decide the point. It wasn't necessary to do so, because the case could be disposed of on the facts by reference to the rights of those who were in the Netherlands. If you looked at their rights, it was still hopeless and inadmissible, even if you focused on the rights of those who were in the Netherlands. You didn't need to go and look at anything else, because even those who undoubtedly had rights could not make the Article 8 case stick. So that's all I say about ground 2. Ground 3, very, very briefly. The new note has come in. I'm hoping it doesn't do, indeed I know it doesn't do, because it was in part used as a speaker for this morning, doesn't do more than I've done orally anyway. What I hope is helpful is to tie some of it back to the references in the Upper Tribunal, judgment. One other reference I wanted to add in response, I think, to a question that my Lord Justice Dingemans raised about where in the judgment did the Upper Tribunal deal with the extent of family life, the weight of family life. It's only the uncle, that point. And can I just add in relation to that, it probably needs to go at the bottom of page 1 under the second heading, Approach to Nature of Family Life. Can I also invite you to add 172 to that little list of references? 172 is the paragraph in which they say we give very considerable weight, or we give considerable weight to family life. So can I invite you to add that in? The only point I wish to, two other very final points in relation to ground 3. The point to be emphasised, perhaps, is that this is not some sort of carve-out from Article 8.2. The broader concern which fundamentally exercise the government flow inexorably from the logic of the reasoning in this case. That's why I went to the trouble of trying to take you through what factors the Upper Tribunal did and didn't ultimately place weight on of any significance. And they ultimately came down to family life, great weight attached to that, and the best interests of children and the risk of death. And of course, those features, is the concern, are not uncommon, as the court has pointed out on numerous occasions, and as Mr. Ransbottom's evidence perfectly clearly indicates. Might be thought that he's indicating the self-evident, because the concern is that if it's enough that you can establish a more or less tenuous connection with family life in the United Kingdom, and then you can simply rely on the awful conditions which exist in various parts of the world and cover very many people, that opens the door through Article 8, and it risks undermining the very clear distinction that you have from the Strasbourg case law between Article 8 and Articles 2 and 3, which you are undoubtedly, and as everyone accepts, not allowed to rely upon. But suddenly, Articles 2 and 3 in those foreign jurisdictions or equivalent even though they're not within the jurisdiction and even though they couldn't make a claim about it, suddenly become the driving feature under Article 8. And finally, Quiller, I'm sure it's a decision much beloved of my learned friend, but it is, we respectfully submit, a very, very different case. It does not stand for the general proposition that in order to make good a self-evident and logical proposition about the extent of impact on a public interest, that you need evidence. Even if you do, we've got it. Nor does it stand as authority for the proposition that in matters of judgment about social matters of this kind, the state is not to be accorded a broad margin of appreciation.
I mean, is it really consistent with later cases about the margin of appreciation, for example, SC?
I respectfully submit that it's directly inconsistent with those cases, SC in particular. But there was a case that I can't remember about landlords in the context of immigration where the judgment of the Court of Appeal was given by Lord Justice Hickenbottom, JCWI I think it was called, where the same point is made about it not, because the debate in those days, my lady will remember, was all about whether that principle was restricted to social security.
Yeah.
The answer was it wasn't. It flows from the constitutional functions and the judgments that need to be reached. So we respectfully submit that Quiller does not assist my learned friend. And perhaps finally, and to emphasise, we are here dealing with the asserted existence of a positive obligation on the state. And you can only find that if, as my Lord the Master of the Rolls has repeatedly pointed out, that the tests that are set out in Article 8.2 and the balances that it requires are met. My Lords, those are my submissions in reply, my Lord, my lady.
Thank you. More questions?
Just one question, please, if I may. Did you want to make any submissions, perhaps you don't because you didn't mention it, about the decision of this recent decision of this court in Ali, on which Mr. Hussein relied? That was the private life. You've got somehow your private life in the United Kingdom survives.
My lady, no, not really. I think you, I'm not trying to say you made them for me, but that question illustrated what we would have said about that case. I invited the court to read the paragraph which endorsed the relevant, if I can put it this way, Article 1 bit of Lord Justice Burnett's judgment in Abbas.
Yeah.
But I respectfully submit that it's fundamentally different in that case because it's dealing with private life that have been established here, and you don't lose that just because you dip out of the jurisdiction for a short period. It's completely different to the case that we're dealing with, which is about family life.
All right, thank you.
Thank you. Well, we will reserve our judgments in this case, obviously reiterating it's a very important case. When we come to hand down, bearing in mind the public nature of this case and the debate that Mr. Hussein made reference to earlier, I very much expect to give you almost no time to provide corrections before we hand it down. We will give you notice that we're going to hand down the draft at a particular time in advance so you can get a team together to look at it. You can then take an allocated period of time to agree an order as to costs, and you won't have to worry about the draft because it'll already be a handed down judgment. But please be very clear that the draft, if you get it, will be sent to only a limited number of named people, and it is a very serious matter indeed if that judgment goes anywhere to anyone for any other purpose other than sending corrections to the court. When you are agreeing costs and an order, any submissions that need to be made will be taken in writing in the usual way. But subject to that, thank you all very much for what has been, if I may say so, not only very interesting but very serious arguments that we will consider on both sides with the greatest care. Thank you.